Carmen, we're going to be talking today about the impact of estates and probates on real estate transactions.
That's correct. What I'd like to do is talk about probate and how it affects real estate. But before I do that, I'd like to speak about the tenancy in which people can hold a title to property.
Okay.
And there are basically two forms of joint ownership, and that's joint tenants and tenants by the entirety. The only distinction with tenants by the entirety, that's held by husband and wife.
Mm-hmm.
The third is tenants in common, and it's completely different from joint tenants and tenants entirety because those share the right of survivorship. One of the joint tenants dies, the husband dies, it goes to the wife, or vice versa. Tenants in common is usually held by business associates, maybe brothers and sisters, and what it is, it's each individual's interest is survivable. I want to explain to you the vast difference because number one, with a joint tenant, there's a right of survivorship, the other person owns it.
Mm-hmm.
If it's tenants in common or if the property's owned individually, it's completely different because now we have to go to probate court and open a probate. An example being someone calls me and says, my dad passed away and we listed the property. We now have it under agreement.
Mm-hmm.
What do we do? And my first question is, did you ever open up a probate for your dad?
Mm-hmm.
And usually the answer is no. So we have to immediately open a probate. And we open a probate, we have to have an administrator appointed. With a will, you have an executor appointed. Then what happens, the administrator is appointed, okay?
Mm-hmm.
Now we want to sell the property. Well, guess what? We can't sell the property immediately. We have to go back to probate court, get another date, and we have to file what's called a petition to sell real estate.
Mm-hmm.
Now, depends on the judge. I've had some judges who are pretty easy about it. Other judges actually require an appraisal. And that's another expense and another delay. Assuming it's granted, once it's granted, there's a 20-day appeal period, which further puts out the closing. So what I'm trying to do is draw a distinction between having a will and not having a will.
Mm-hmm.
If you had a will, it would have been quite different because most wills have what's called a power of sale in it. And if it was the same set of facts, I would open up the probate, and immediately upon the executor qualifying to become the executor of the estate, we'd have the ability to sell, and we could sell. We don't need a petition to sell. We don't have a 20-day appeal period.
Mm-hmm.
Big difference in time. If you have no will, what happens is Rhode Island general laws set forth intestate succession. So if an individual dies and he has children, his children equally get that person's share.
Mm-hmm.
If he has no children, it goes back up to the parents.
Mm-hmm.
And if he has no parents, then there's a scheme that goes to aunts, uncles, and things of that nature.
Sure.
But one other potential stumbling block is that if the person who passed away was married and left a spouse, that spouse now has a life estate, the ability to stay in that home
Mm-hmm.
for the rest of his or her life.
Without a will or with a will?
Without a will.
Without a will.
Without a will.